Good afternoon, everyone. My name is Chris Leddy, and I would like to first take this opportunity to thank Christine at MSA for her hard work in putting this webinar series together. I am sure each of you will see it as a benefit to your company and or responsibilities. I have the pleasure of presenting today with Sarah Davis. Sarah and I are part of Becker's Staffing Group practice. Becker is a national law firm with offices located along the East and West Coast. We provide legal services to between 125 and 150 staffing firms nationwide in all areas of law affecting staffing firms, from employment law to corporate governance, contract drafting and negotiation, commercial litigation, and mergers and acquisitions. Today, we are happy to present information on the Multistate Employer Considerations. Please, at any time, feel free to ask any questions you may have during the presentation. Also, if you wish to speak with us offline, please don't hesitate to do so afterwards. So let's jump right to it. Obviously, many of you operate in more than one state. While you're likely providing similar services in each state, not all states are created equal in the employment law context. Each state has its own nuances that must be followed, and when employing or having workers working in a specific state, while this seminar will not cover all the topics and nuances, we will try to address what we have seen as the trending issues. The first topic we're going to talk about is predictive scheduling. Essentially, because of deregulation at the federal level, there's been an increased regulation at the state and local levels. This includes a growing trend of legislation related to the workforce, including changes to things such as paid time off. Applicable to this topic, numerous state and local governments across the country have passed or considered passing ordinances regarding predictive scheduling, more commonly known as the Fair Work Week laws and ordinances. The overriding public policy behind the Fair Work Week laws and ordinances are to assist and protect workers who have traditionally been at the low end of earning power, and at this time primarily affect the retail and food service industries.
Hey, Chris, can you just elaborate a little bit more about the public policy reasons?
Sure. So the most common rationale that has been voiced for Fair Work Week legislation includes the desire to eliminate the burden of not knowing scheduling in advance, which affects the ability of employees to care for their children, attend school, similar activities. Also, the desire to eliminate the burden of not knowing what employees' wages will be from week to week, whether or not employees' days off are truly off or if they're on call for work. Essentially, employees must have a work schedule that gives them the ability to plan their lives in advance and beyond their work. The government's position on these laws and ordinances is that equity is afforded, or that the equity promises to provide basic rights to employees who are often at the lowest end of the employment ladder, for whom unexpected scheduling can have a devastating impact on their financial situation. Conversely, the government also maintains that there are benefits to employers, such as predictive scheduling equals predictable wages.
Oh, Chris, can I just interrupt for 1 second, because I think it's important. You know, I'm a mom. I have a child. In regard to daycare, if you don't know your work schedule, that's hard to determine what daycare days would she be going. I can imagine the impact could be devastating.
Yeah, so a lot of people may get fired, may lose their jobs, but for these policies, especially, like we said, the low-income people, they have to be able to plan. They have to be able to make a living.
Sure.
If they can't make that plan, can't make a living, they can't hold a job down. So I think that's the basic reason they passed this law.
Right, and I agree with you what you said about the schooling as well. If you're trying to go to school to get a degree, you can't schedule classes. It seems like you said, it's significant.
Yeah, it allows people to better their lives all around.
Sure.
So Sarah, question for you. What states and localities so far have passed Fair Work Week laws?
So as of today, the state of Oregon is the only state to have passed statewide Fair Work Week legislation. However, several cities, including New York, San Francisco, San Jose, Seattle, have enacted similar protections at the local level. Just recently, in December 2018, Philadelphia passed a bill known as the Fair Work Week Employment Standards, making it the second largest city behind New York to adopt such an ordinance. The Philadelphia ordinance will take effect in January 2020. However, it's also important to be aware that many other jurisdictions are also anticipated to join the above list soon. This includes states such as Connecticut, Illinois, Maryland, New Jersey. They're all currently considering similar legislation. Furthermore, in addition to these comprehensive Fair Workweek laws, there are several states, including New Hampshire and Vermont, that have passed right-to-request statutes. This grants all or most private sector workers the right to request scheduling accommodations, for example, shift accommodations. While these Fair Workweek laws are more limited in scope, they apply to a broader segment of the workforce. For instance, over 1 million workers now enjoy increased workplace flexibility because of these right-to-request laws. So, Chris, can you just get into a little bit how, all these laws are not exactly identical, and maybe just tell us some of the common elements?
Yep, sure. Like you said, Sarah, they're not all identical, so they do vary from state to state, or in this case, locality to locality. I'm sure each state, once they pass, will be slightly different as well, so you have to be aware of those nuances. But in general, these laws or ordinances require employers to provide their employees with advance written notice of their work schedules ranging from anywhere from 7 to 21 days. They require employers to provide employees with a good faith written estimate of their work schedules on or before their start date. They require employers to permit employees to decline working altered shifts or schedules without retaliation if changes are made with a delineated notice window, and or if employees receive premium pay at a flat rate or hourly rate for working the altered shifts, with typical exceptions such as if the employee is already being paid overtime for the time or voluntary shift swaps. Also, the employers are required to offer current employees available shifts before they hire new employees or go outside, in our case here, to staffing firms. So it could have a big impact with the staffing industry. But it's important to note that their current employees who are offered the time do not have to be offered the time if it's going to count as overtime. So once they hit 40 hours, no further work has to be offered to them. Also, these ordinances do impose mandatory rest periods between shifts. They have a right to request scheduling accommodations, which we talked about the reasons for prior. There's also notice and record keeping requirements, which employers must post in their workplace and give them sufficient notice to comply with it. For some examples, San Francisco states that all employers must provide employee schedules at least 2 weeks in advance. They cannot make any changes to any employee schedules with less than 7 days notice. Changes made past the deadline would mean employers will have to pay employees 1 to 4 hours of pay or penalty pay. On-call employees must be paid 2 to 4 hours if they are not required to work. In Seattle, you have to provide rest periods to avoid clone opening. This is when an employee closes a location and opens the next morning. Shifts cannot be scheduled less than 10 hours apart unless the employee consents. In such case, the employers must pay time and a half for the hours separated by less than 10 hours. You have to provide, again, 14 days notice in advance of the schedule. Also, you have to provide additional compensation for schedule changes after the posting. So if added hours must include 1 hour of additional pay beyond the hours worked. If you subtract hours, it has to be those hours subtracted have to be paid at halftime. For on-call hours, if the employee is not required to work, again, it has to be paid at halftime. So, Sarah, can you give us some background on what is happening in Massachusetts with regarding this?
Sure, and also I just wanted to step back for 1 second and talk about the states that have these requirements to post notices to the employees, letting them know of their rights, how important it is to actually post those notices in a place that employees have access and can read them.
Yeah, for sure. I think that's a good point because a lot of staffing firms, might not actually meet these people.
Exactly.
So it's a good practice to have it as part of your onboarding, to give them these notices, sign off that they received them. That way, nobody can ever come back and say, I didn't know.
Right. You want to avoid that at all costs of employees saying they didn't even know they had this right because, you forgot to or didn't post sufficient notice.
Correct. 100%.
Yes. So anyway, getting back into Massachusetts, at this time, Massachusetts is one of the states considering catching up with the above laws and regulations. For instance, just this year, Senate Bill 1110 was introduced, which provides standard fair workweek protections for workers in retail establishments, restaurants, and in the hospitality industry. The benefit to employees afforded under this new legislation includes providing workers with 14-day advance notice of their schedules, the right to rest between shifts, additional protections against retaliation, and penalties for noncompliance. Also, Senate Bill number 1102 was introduced in 2019, which is a more sweeping and less defined legislation that requires employers to post a 7-day schedule in writing at least 7 days prior to the first day of that work schedule. However, I think it's also important to realize that even though these bills were introduced, it doesn't mean that there's been no opposition to these types of fair workweek laws. More specifically, the Massachusetts legislature held a hearing regarding the foregoing legislation on April 9th, 2019, very recently. At the hearing, several representatives argued that the proposed legislation's quote-unquote one-size-fits-all approach unreasonably restricts an employer's ability to adjust to unforeseen circumstances, such as, call-ins by employees. Moreover, it was argued that the cost associated with the proposed legislation compounds the leave laws already enacted by the state. Further, with more opposition, opponents also argued that the proposed legislation amounts to overreach on the part of the state, since it seeks to unfairly control employers' day-to-day operations for selected industries. So the above definitely highlights the fact that not every state is in agreement with these fair workweek laws. Significantly, several states are so against it, including Arkansas, Georgia, Iowa, Michigan, just to name a few, that they even have enacted laws preventing municipalities from enacting these kinds of laws. So I think that's also significant. Getting more into this, Chris, can you please discuss some more of the opposition that's being faced right now by these laws?
Yeah, I think that's a great point because I know organizations such as ASA are currently fighting legislation and ordinances such as these because it is going to harm or could conceivably harm staffing agencies because of the on-call nature. If your clients don't want to have people on call, you're going to have people on call. And if you have to have people on call, then it's obviously costing you more money, costing your margins. You have to redo your labor burdens. So it's a lot that goes into this, and I think really the biggest people that are going to be hurt could be staffing agencies down the road. Obviously, right now it's people in the retail and service industries, but your rights are being fought for. So
Sure.
I wouldn't think this is definitely going to go as planned everywhere. As far as some opposition that has been filed so far in New York, the International Franchise Association, along with the New York Restaurant and the National Restaurant Associations, challenged New York City's Fair Workweek law, arguing, among other things, that the law is preempted by state labor laws. The IFA also argues that the law unfairly targets franchise owners, resulting in an unfair advantage to small mom-and-pop businesses who are less likely to need to comply with the law. This case should be tracked and watched for its outcome, as the way it is reviewed and decided will likely be persuasive in other locations. It's also worth discussing that New York City's Fair Workweek law are particularly troubling for employers because of its expansive definition of a covered employer. So a covered employer covers temporary staffing agencies and subcontractors, including employers providing janitorial and security services. In other words, the general perception that the law is limited to retail and fast food employers is not the end of your inquiry. If an agency stocks supplies, cleans, or provides security for retail or fast food businesses, their employees are going to be protected by this law, and the agency is a covered employer as well.
Now, I just want to, because I find that very interesting. So even though this law impacts, fast food workers and those type of industries, if you're a staffing firm and you're placing in those industries, then it affects you as well.
Yeah. So if you have a janitor at McDonald's,
right,
that you're staffing, you're going to be a covered employer in that case.
Oh wow. Okay.
And while it's, like we said, just primarily in the retail and fast food industries right now, or the hospitality industry, there's no reason to think that these fair work laws won't be applied to other industries as well. I would think that the next industries are LI and clerical sectors. Like any other progressive employee-friendly law that we've seen implemented in the past, this is likely just the beginning. Further, there's likely to be more positions, jobs subject to these laws once the FLSA is amended with a higher salary threshold in January 2020, making less workers exempt, as these laws primarily apply to non-exempt workers at this time. And now I'm going to flip back to Sarah to talk about ban the box.
Thanks, Chris. So another major trend over the past few years involves background checks and is referred to as the ban the box legislative movement. The box refers to the question on job applications that ask applicants whether or not they've ever been convicted of a crime. Ban the box law requires employers to remove this question, as well as any other queries about criminal history from job applications. This legislation is meant to prevent employment discrimination against individuals with criminal records. The main idea is that employers get a chance to form an initial impression of each applicant's specific character before they react to any stigma that comes with a criminal history. As of today, at least 35 states, Washington, D.C., and over 150 cities and counties have adopted ban-the-box legislation. Moreover, at least 12 of these states, including New Jersey, Washington, California, go so far as mandating the removal of conviction history questions from job applications for private employers, so it's not just public. This is a crucial step towards ensuring that people with records have a fair chance at employment in the majority of jobs. Also on the national level, President Obama endorsed the Ban the Box movement by directing federal agencies to delay inquiries into job applicants' records until later in the hiring process, so that was big. Chris, can you take us through an example of Massachusetts?
Sure, and just so we're clear, there are some exceptions to the laws that each state or locality does have. If you're in the law enforcement, obviously, that's going to be a different. If you're a teacher, certain professions are exempt from these ban-the-box laws. But as far as Massachusetts, it enacted its modified ban-the-box law in August of 2010, which prohibited the following: employers from asking about any information related to a job applicant's criminal record in the initial written application, and employers from requesting certain criminal record information from applicants at any point in the application process, even after receiving the initial written application. Specifically, following the enactment, employers could not request information from an applicant, either written or orally, regarding an arrest, detention, or disposition regarding any violation of law in which no conviction resulted, a first conviction of a misdemeanor for drunkenness, simple assault, speeding, minor traffic violations, affray, or disturbance of the peace, any misdemeanor where the date of the conviction or completion of incarceration occurred 5 years or more prior to the date of the application for employment, unless the applicant has been convicted of any offense in that same period. I think the simple assault question is the one I get a lot, because you don't want to put somebody who's potentially violent into the workforce, and then obviously you have liability. Unfortunately, this law kind of takes it out of your hands. You might have to try to find a different way to get around that. In April 2019, this Massachusetts law was amended. It decreased the time period for disclosure of misdemeanor convictions. Employers are now prohibited from asking applicants, either written or orally, about any misdemeanor where the date of the conviction or completion of incarceration occurred 3 years prior, which was 5 years, to the date of the application, unless the applicant has been convicted of any offense in that same time period. There's also a new restriction regarding sealed or expunged records. Employers are now additionally prohibited from asking applicants, either written or orally, about criminal records that have been sealed or expunged. And there's also required notice language that has to be given to applicants. You have to inform applicants that for certain expungements, they can state that they have no record, even if they do. As an example of the seriousness of compliance with this law, recently, on May 6, 2019, the Massachusetts Attorney General announced agreements were reached with 2 Massachusetts employers with warning letters sent to another 17 businesses after finding them to be in violation with the state's ban-the-box law. In all these instances, the businesses still included a criminal history question on the initial employment application. The agreements reached with the two businesses required a $5,000 payment to the state. So as you can see, they're taking this seriously and going after people who are doing this. More likely, people are reporting them, and then the Attorney General is probably doing an audit, which nobody ever wants to be in an audit, because once they start auditing, you never know what they're going to find. So, Sarah, can you provide us with a brief description of some other states' laws?
Sure. And again, I just want to preface this with what you said earlier. Of course, there are going to be exceptions in states for, certain jobs. This is more general, and employers should, speak to someone specific into jobs in case there's any question about whether these apply or not. So again, generally in California, law prohibits employers with 5 or more employees from making criminal inquiries until after conditional job offers have been made. Connecticut law prohibits all employers from making criminal history questions on initial job applications as well, with very limited exceptions. Rhode Island law prohibits employers with 4 or more employees from making criminal history inquiries on initial job applications as well. So in New York State, there's no state limitation. However, several cities such as Buffalo, Rochester, Syracuse, and NYC, New York City, have all enacted city-level legislation. As example, in New York City, employees with 4 or more employees are prohibited from making criminal history inquiries prior to conditional job offers. As an example of this, the New York City Commission on Human Rights continues to be an active enforcer. Just recently, in March 2019, the Commission announced a significant settlement, almost $200,000 in damages in this regard. In this case, the employer rescreened an employee following an acquisition and uncovered a felony conviction from the early 1990s. The company then refused to hire the individual on the basis of this conviction. Following an investigation, the Commission Law Enforcement Bureau determined the employer failed to consider relevant laws such as the ban-the-box movements and giving everyone an equal opportunity and chance for the job. In addition to the monetary payments, the employer was required to develop a comprehensive Fair Chance Act policy, make postings at its New York City locations of rights individuals have under the law, again, going into the posting and making sure everyone has access to those postings, and provide training to relevant HR and management employees. So looking at that and the damages and the monetary results, all employers really need to take time and review new legislation in addition to their compliance with existing laws. The landscape continues to become more difficult for employers that hire in multiple jurisdictions, but as this New York City case demonstrates, non-compliance can be very costly.
Yeah. For our attendees, would you recommend that they have a conditional job offer letter so they can make sure that they can do this?
Right, I agree.
Yeah,
I agree.
Yeah, definitely not in the application stage after you interview them.
To be safe, definitely get that conditional job offer.
Yeah, they can sign a contract. Yeah, have them sign the contract, have them sign the offer saying that it's contingent upon them passing satisfactory, passing a criminal background check.
Chris, now I'm going to turn back over to you to discuss the next topic and the effect of the Me Too movement. Awesome.
So another major trend we've seen throughout all the states is obviously the Me Too movement. Everybody's aware of it, and it's resulting in much stricter sexual harassment legislation. At least 11 states, from California to Vermont, have passed protections addressing workplace harassment in 2018. Which include but are not limited to the requirement of mandatory harassment training and education in the workplace. For instance, in 2018, California passed a lot of legislation, but 3 of them that we're going to talk about is the first one is Senate Bill 1343. It requires employers with 5 or more workers to provide sexual harassment training to supervisors and non-supervisor employees all by January 1st, 2020. Under the 2005 law, the state mandated 2 hours of mandatory sexual harassment training for supervisors of employers with 50 or more employees. So obviously, now it doesn't only apply to large employers; it also applies to small employers.
Yeah, I feel like that's a big decrease there.
Yeah, it's certainly a big cost to small companies because you're having to pay your employees to take this training. You can't just have them do it for free, because if you do, then you're getting into wage issues, and nobody wants to be involved in that, for sure. Also, I think it's just worth mentioning in California too. If you have somebody working there, it's 30 days or 100 hours, whichever comes first. They have to have the training done by. Senate Bill 1300 prohibits employers in California after January 1st, 2019, so after January of this year, from forcing employees to sign a non-disparagement agreement to release the employer of claims, including for sexual harassment, as a condition for a raise or bonus or condition of employment. That said, there are exceptions when the employees voluntarily agree to waive rights in an agreement. The bill also strengthens sexual harassment training by authorizing employers to provide bystander intervention training. So
now, I feel like if you're going to use that exception, if that exception is going to be used for the waiver, there should make sure that you go through all the protections so that that's truly waived and there's no issues coming back.
Yeah, hopefully the other side has counsel,
Sure.
And if they don't have counsel, you want to put in the agreement that they have been notified that they should get counsel, and if they haven't, they're voluntarily waiving it. And I would put in bold.
Specific as possible.
Yeah, bold it. Do whatever you have to do to it to make it stand out, for sure. Also, the bystander intervention training is something new that we've seen. New York also has it. It's to teach people how to deal with sexual harassment when they see it. They're not the victim, but they see it occurring, how to approach it, how to deal with it, how to report it. Not everybody's comfortable.
Yeah, I think that's a huge deal, because if you see it, I feel like a lot of employees would be nervous about any sort of retaliation, or if they told. I feel that is a big issue. Yeah,
and I think that's a major reason that this is being implemented. I think bystander training is a good thing, for sure. Mm-hmm. The last bill that was introduced this past year was it applies to private and public employers in California and outlaws secret settlements or non-disclosure agreements of factual information in cases involving allegations of sexual assault, harassment, or discrimination. It took effect on January 1st, 2019. It also grants claimants in sexual abuse or sexual discrimination cases the option to keep their name private. So basically, if they want to they can keep it confidential, but employers don't have the right to. This is really what started the whole Me Too movement, I think, like the Harvey Weinsteins.
I was going to say, too, your opinion, do you think a lot of this was helped by, the social media? Because it went nuts with social media, and now, it's funny when you're looking into these new bills that are being passed, you read them, and you can't believe that this isn't already enacted. You take it, you read it, and it's unbelievable in some circumstances.
Yeah, a lot of these bills, a lot of states have passed bills similar to this, where there's anti-confidentiality, but the anti-confidentiality, for some states anyway that have passed it, I don't think are totally well thought out, because if they have to keep the information public and they can't, maybe the victim doesn't want it to be public. Maybe the victim doesn't want that information following him or her around the rest of their lives. So I think some of it needs to be amended to include certain provisions. So Sarah, along those lines, what are some of the other states doing in the wake of the Me Too movement?
Sure. So recently, in October 2018, a New York state law, referred to as the 2019 Budget Act, went into effect, which requires all employers to have a sexual harassment policy that meets minimum requirements. More specifically, the 2019 Budget Act includes, this is not an exhaustive list, it prohibits employers from using a mandatory arbitration provision in an employment contract in relation to sexual harassment. It requires officers and employees of the state of any public entity, such as municipal government, to reimburse the state for any state or public payment made upon a judgment of intentional wrongdoing related to sexual harassment. I think that's a big one. It ensures that non-disclosure agreements can only be used when the condition of confidentiality is the explicit preference of the victim, which is exactly the point you were making prior. It amends the state's human rights laws to protect contractors, subcontractors, vendors, consultants, or others providing services in the workplace. So now it just doesn't encompass employees. It's it's all those that I just named as well.
Yeah, which is big.
It's big.
Big for especially for the staffing industry. If you hire subcontractors, it's you could be on the hook for
exactly
sexual harassment.
It also establishes minimum standards for sexual harassment prevention policies and training. More specifically, all employers operating in the state are required to either adopt and use the state's model policy and training as is, or to use the models as a basis to establish their own policies and training with a minimum of the state's requirements. Also, all employees working in the state must receive sexual harassment training. Now, this is different because in Massachusetts, the Massachusetts Fair Employment Practices Act prohibits sexual discrimination in the workplace, including same-sex sexual harassment, which is also big these days. There are two main categories of sexual harassment: quid pro quo harassment and hostile work environment harassment. Now, to guard against the above, Massachusetts law requires employers with 6 or more employees to adopt a written policy against sexual harassment. The employer's policy must include notice to the employees that sexual harassment in the workplace is unlawful, and that it is unlawful to retaliate against an employee for filing a complaint of sexual harassment. That goes back to the point we talked about before about the retaliation. The policy should also assert the employer's commitment to investigate any complaint of sexual harassment. For convenience, the Commission has prepared a model sexual harassment policy and a poster to help policy formation. However, and like I said before, unlike several other states, at this time, Massachusetts law only encourages employers to conduct education and training programs on sexual harassment on a regular basis. It's not required, which is, could be a problem because under Massachusetts law, an employer is liable for sexual harassment of employees by managers and persons with supervisory authority, but also liable for harassment committed by persons without actual or supervisor authority, also by non-employees such as customers, patients, clients, independent contractors. So the list is big. So employers can be on the hook. So Chris, considering what I just said, what do you recommend for employers whose principal place of business is not in a state such as Massachusetts, which requires training?
Yeah, and obviously everybody should consider training. Training and policies are 2 big defenses that any employer has when a discrimination lawsuit is brought against you. Because obviously, if you have the policy, you can say, well, here's my policy, here's my reporting procedure. They didn't follow it. I didn't know about it. What am I supposed to do if I don't know about it? So in that case, that would be your defense. Federal courts have consistently held that is a valid defense. They also recommend training to go over each policy. You should distribute it annually. You should do the training annually. For staffing agencies, you probably want to do it at the time of onboarding. Again, like we talked about, we know it's an expense, but it could save you tens or hundreds of thousands of dollars down the road. For example, even Connecticut, right next door, requires all private and public employers with 50 or more employers to provide 2 hours of sexual harassment training to supervisory employees within 6 months of assuming that position.
So even if the state doesn't require, even if it's something like 2 hours, it's good to make that a requirement.
Yeah.
It would be beneficial.
Yeah, it can only help you. Again, if you don't have it, you lose your defense. You really don't have a defense of I didn't know about it. Well, if you don't have a policy saying that this is how you tell me about it, then it's on you. It's not on the employee.
I think that's a good point too. If you have a policy saying this is what you do, this is how you tell us. If they don't, then it's not on the employer.
Yep. Yeah, for sure.
Always try and have something like that in place.
Yeah, no. The more policy you have on sexual harassment, the better. The more training you have, the better, for sure. Now, our next topic we're going to turn to is paid sick leave throughout the states. Obviously, this is a very, very trendy topic throughout the country. I'm going to turn it over to Sarah.
So there is no federal law requiring paid sick leave. Even the Family and Medical Leave Act of 1993, which requires employers of 50 or more to provide medical leave, doesn't require employers to pay employees while they're on leave. However, several states and localities have implemented their own sick leave laws, which employers in such states or localities need to be aware of and in compliance with. You want to give us some examples of the states?
Sure. So in California, any employee who works for 30 or more days within a year from the beginning of employment is entitled to paid sick leave. They earn at least 1 hour of paid sick leave for every 30 hours worked. They start accruing time on their first day of employment, but you don't actually have to allow them to use it until the 90th day. So again, these are employees that maybe they're your employees, you're located in Massachusetts, but they're working in California. An employee can take a paid leave day for their own or a family member's care, illness, treatment, or preventative care. Also, it applies to a victim of domestic violence. There are some exceptions. Most of the time, for our purposes, they're not going to apply here. But good news is you can, in California, limit it to 24 hours use and accrual in a year. So even though they may accrue 24 hours if they don't use the 24 hours, 24 hours do roll over, and they could actually have 48 hours in 1 year, but they're only allowed to use 24. So really, some of the hours are just always going to hang out there then at that point. I just want to point out, too, that depending on where you are in California, where your employees are, there's numerous cities throughout the city of California that are a lot more pro-employee, which require you to offer up to 9 days of paid sick leave per year. In Connecticut, each employer with 50 or more employees shall provide paid sick leave annually to each employee in the state. The paid sick leave shall accrue beginning on their first day of employment. Unlike California, it's 1 hour for every 40 hours worked. They're entitled to use it after they worked at least 680 hours, which equates to about 17 weeks. However, an employee shall not be entitled to use the accrued paid sick leave if the employee did not work an average of 10 or more hours a week for the employer in the most recent complete calendar quarter. Similar to California, an employee may take its paid sick leave for its own care, its family members' care, medical diagnosis, treatment, as well as for domestic violence. Sarah, can you tell the audience about the Massachusetts law?
I can. So under Massachusetts law, the law requires all employees whose primary place of employment is Massachusetts to be eligible to accrue and to use paid sick leave. Or, in the case of employers with fewer than 11 employees, unpaid sick leave. Employees are eligible to earn up to 40 hours per year of sick leave. Like the foregoing discussed states, the number of hours to which an employee is entitled is related to the number of hours that they worked. More specifically, workers must earn at least 1 hour of earned sick leave for every 30 hours worked. Accrual of sick time begins on the employee's first day of work, but may not be used until 90 days after their start date. Like the other laws discussed, sick time under this law is permitted to be used to care for the employee's own physical or mental illness, to care for a child, parent, spouse, or parent of a spouse who is suffering from a mental or physical illness, and to address the effects of domestic violence. Another interesting point in regard to this law that is beneficial for employers to be aware of is that if an employee's absence from work requires the company to call in a replacement worker to cover the absent employee's job functions, the company may require the absent employee to use an equal number of hours of sick time as were worked by the replacement. So again, that's beneficial for the employer to know and be aware of those types of laws.
Yeah, sure.
Right. Since as shown above, the laws vary between states and even some cities, just as you said, Chris. So we suggest that you always work with reliable HR and payroll providers to ensure your company's compliance with these laws, because again, non-compliance can be costly.
Yeah, for sure. And most of these states do require that you put the accrued paid sick leave on their pay stubs each pay period. And if you don't, that's a different violation. So there's a lot of different ways that you could violate this. Again, like Sarah said, make sure your payroll provider is on top of this. Make sure that your payroll provider, your contract with them, indemnifies you if they screwed up.
Good point.
Because if they don't, you could be on the hook. And no, again, nobody wants to be
and it's
down by
hard.
the government.
There's so many specific, different laws here. It's hard to keep track, which is why, again, it's just so important you are confident in your HR and management personnel.
For sure.
So I'm going to get into our last topic, a very trending topic, and that's the use of medical marijuana, and specifically how medical marijuana laws are interpreted in different workplaces, for example, different states. So the interpretation of these laws are conditioned upon a few factors. The first being if the work is funded by the federal government, the federal law will apply. And then if not federally funded, state law applies. Lastly, it depends on the company's tolerance of usage. So in regard to that first point, federal funding, on the federal level, marijuana is a Schedule I drug under the Controlled Substance Act. This means that it has a high potential for abuse, has no currently adopted medical use, and is a safety concern. Therefore, it's still a crime to possess, sell, distribute, or manufacture it on a federal level. So you may be thinking, why has the federal government not sought to prosecute medical marijuana users other than the optics involved? Well, that's because the Rohrabacher-Blumenauer Amendment prohibited the U.S. Department of Justice from using funds to prevent state implementation of medical marijuana laws. In the case of United States versus McIntosh, the court held that this amendment prohibited the DOJ from spending funds for the prosecution of individuals who engage in conduct permitted by state marijuana laws. So that's big. Likewise, the Cole Memo issued by the Obama administration in 2013 directed a largely hands-off approach on the part of the government when it came to states' administration and enforcement of their own marijuana laws. However, in January 2018, the Attorney General revoked the Cole Memo, thereby permitting the federal government to enforce the federal laws regardless of what state laws say. It will be interesting to see how this plays out.
Yep, there's good points there. I think just to back up what Sarah said, working on a federal contract, if you're working on a federal contract, it doesn't matter what your state law says.
Right, correct.
You can't employ a medical marijuana user. Yeah. So anything that you're getting federal funds on, it's hands off, even if you're a subcontractor.
Right, no matter the state law. So Chris, can you just explain how the ADA comes into play in this regard? For
sure. So many of you are probably thinking, well, what about the ADA and accommodating a disability through medical marijuana? It's a great thought. It just does not help on the federal level. Under the ADA, a person currently engaging in the illegal use of drugs is not a qualified individual with a disability. This makes sense because both the ADA and Controlled Substances Acts are federal laws.
I think this is important because I think there's a lot of misunderstandings as to this.
Yeah, they have to, obviously you have to marry them up. So, right. So then next thing we talk about is what about state laws? There's really not a lot of case law out there yet challenging the state laws, but it's definitely developing. Employers currently rely on the federal preemption as a defense for cases involving marijuana use. This means employers assert that federal law preempts medical marijuana laws and state laws must be interpreted consistently with federal law, namely the Controlled Substances Act. The high courts of Oregon and Colorado have followed these interpretations. In a Colorado case, there was an employee that was a quadriplegic who held a valid registration under Colorado to use medical marijuana. The employee alleged she was never impaired at work and was a model employee. After 3 years of employment, the employee tested positive for marijuana and was discharged. He then sued the employer alleging a Colorado statute prohibited discrimination against an employee for engaging in a lawful activity during non-working hours, namely in this case smoking marijuana. So this is like your ideal plaintiff. I think you have a home run here, and the court says differently. The court found it was not a lawful activity, notwithstanding state law, because it is prohibited by the CSA, Controlled Substances Act. The key in this case was the medical marijuana statute did not contain an express prohibition against employment discrimination. You contrast that with the Second Circuit case under Connecticut's medical marijuana law. And in addressing the preemption issue, the court stated that CSA does not make it illegal to employ a marijuana user, nor does it purport to regulate employment practices in any manner. It also contains a provision that explicitly indicates Congress did not intend for the Controlled Substances Act to preempt state law unless there is a positive conflict between the two. The court distinguished the prior discussed case as Connecticut's law had a clear provision that provided employment protections for medical marijuana users. Likewise, in Massachusetts, the court found that the state's medical marijuana statute that states no person should be penalized for using medical marijuana was persuasive, resulting in a win for the employee. Michigan has very similar language. The court there in an unemployment case found for the employee, Rhode Island as well. I think perhaps the most shocking stance on medical marijuana is California, as California is known as a very progressive, employee-friendly state. The courts there have consistently held that California's law does not require employers to accommodate the use of legal drugs. In fact, in one of the cases in California, the court actually stated there is no evidence the plaintiff was fired because of his disability and not because of the way he chose to treat the disability. So again, he wasn't fired because of his disability, but because of the way he chose to treat it, which was illegal under federal law. Likewise, the New Jersey District Court upheld the termination of an employee for the same reasoning, the way the employee chose to treat it. Although a New Jersey State Court recently ruled the opposite way, leaving employers in New Jersey in a state of haze. I mean, no pun intended. Thus, there's no clear-cut answer on whether medical marijuana is permitted under state law, as it varies really state to state, and still evolving. Not every state even has medical marijuana laws yet. There's about 30 of them that do. I would say when you're in doubt, engage in the interactive process by seeing if any accommodations can be made, including possibly a different medication that the employee could take.
Now, would you suggest that to the employee?
I would have the employee ask his or her doctor if there's possibly anything else that they could take. Again, it really is going to depend on the position too. If you're in a safety-sensitive position, that's different. It depends on your culture, what your clients require. So it's not a one-size-fits-all approach. We have a question.
Trying to figure out how to view the questions.
Sorry.
Okay.
So the question is, in Massachusetts, if an employee accrues 40 hours, do you have to stop accruing? For example, if an employee carries over 40 hours into the 2019 but does not use them until the last week, December, do they have 0 hours to carry over into 2020, or do they accrue hours for 2019? So no. So if they accrue 40 hours in 2018, don't use them, all roll over to 2019, they then start accruing. They can bank up to as much as another 40 hours, so up to 80 hours, but they can only use 40 of those 80 hours in 2019.
Funny, because we were just talking about this yesterday when we were preparing for this.
So basically, then in 2020, they have 40 hours carried over, which you could look at. They're really 40 hours from 2018. So back to marijuana. Sarah, what are some of the best ways to deal with these issues?
Sure. So just to kind of finish this up, it's always best practice to create a very strong internal policy, especially with something as sensitive as medical marijuana and all the topics that we've discussed today. As you may know, the EEOC does not favor zero tolerance policies. However, being a federal organization, the EEOC does not recognize medical marijuana as a medication. Thus, it might be okay in this instance. I, and Chris as well, would recommend drafting a policy for each respective state so it's clear to all employees what's expected of them in regard to medical marijuana.
Yeah, and that just goes back to the fact that every state law is different. I mean,
I think that's the ongoing conclusion in our whole.
Yeah, I think if
many different state laws.
I think it's depending on what happens with politics and 2020 election,
right.
This may all be moot, and you may have a federal level.
Sure.
Which would be nice, in some respects.
Right. So lastly, it's important to, as an employer, review job descriptions for safety-sensitive positions, train managers in identifying and testing in regard to medical marijuana, and have concrete testing procedures. You could use the DOT regulations as a guide.
Right. So all in all, it's important to research each state you're in or plan on expanding to learn what is required, even outside of what we covered here today. For example, some states require notices to be given to employees. Some states have different overtime exemptions, which don't follow federal law. So just because you rely on federal law, obviously what we talked about here today is not going to be enough.
Sure.
Also, some states have different insurance requirements. These are considerations that should be taken into account before engaging in an out-of-state practice.
Yeah, I think that's a big, what you just said, insurance. We didn't really touch upon that so much, but I think that is also, you know, a big thing to look into.
Yeah. And if anybody has any questions, feel free to ask. Otherwise, that concludes our webinar today. Thank you for attending.
A lot of information, we understand.
Yeah, feel free to email Sarah or myself.
Right.
Any questions you may have, happy to answer them. And thank you again for having us. And we're now going to end the recording.